What makes a good objection in court? Well, when we have hearings or trials in court, they're governed by the rules of evidence, and there's a Connecticut Code of Evidence, and most states have similar types of objections and similar codes of evidence. But your lawyer, who's a trained trial lawyer, really should know the Code of Evidence well. And really what you're supposed to do is stand up and say, objection, leading, objection, hearsay, objection, foundation. You're supposed to just give that information. If the judge wants more, they'll ask you. That's what the rules state. In reality, what happens? Sometimes judges are more permissive. They allow things like speaking objections. So some lawyers that aren't as trained in these types of things will give speaking objections. Sometimes I will even use that as a technique. Even though I'm solid on the rules of evidence, I'll use a speaking objection if the judge tolerates that type of behavior because it allows you to be more persuasive. You can sneak things in that under the rules you couldn't just say foundation because, Your Honor, we don't even know what time we're dealing with here. This is outrageous. And if the judge is going to not admonish you for doing that, because the judge controls the courtroom decorum, as long as you're being professional, that could give you a lot of advantage in terms of getting an objection sustained because you're not just being concise as the rules require, but you're allowing the judge to get more information up front and get them to more likely rule in your favor.